There's much to unpack on surveillance capitalism's harms. Today, I will focus my remarks on democracy and political parties before I sit down with Taylor. The mythical 300 Cerberus works hard to keep us in limbo, and I will use it here to represent three contended zones of interest in surveillance capitalism: monopolistic corporations who seek to undermine fair markets, security agencies that seek to expand surveillance at the expense of civil liberties, and three, political parties that seek to manipulate the electorate at the expense of a vibrant democracy. These three corrosive forces have a deep incentive to cooperate, and I believe political parties are the weakest link in this three-legged stool, which is why I'm focused on them. The digital age is shaped by who controls the data, the algorithms that act on it, and the information environments they create. This new era of human commodification violates fundamental human rights in ways that are new. The data generated by our experiences, choices, and even our thoughts get captured, processed, and traded as raw material for manipulative algorithms for profit and power. My comments today will focus on number 7 of this list: political participation and democratic self-governance. The International Covenant on Civil and Political Rights is a multilateral treaty adopted by the UN in 1966 and came into force in 1976 that commits the 174 signatory states to respect the civil and political rights of individuals. These new violations of human rights caused by our digital information era can be mapped to specific articles in this treaty, creating a vehicle to file formal complaints. This slide summarizes the facts in a long-standing legal dispute involving citizen privacy rights and the three political parties. In 2019, three Canadian citizens living in British Columbia expressed their rights under Section 4.1 of the province's 2004 Personal Information Protection Act. The section says that the law applies to any organization operating in the province that collects, uses, or discloses personal information. Three citizens wanted to know what personal information political parties had collected on them, a fair question in any democracy. They wrote the Liberals, the Conservatives, and the NDP, and all three parties refused to answer. So the citizens filed a complaint with BC's Privacy Commissioner, and my Centre for Digital Rights agreed to pay their legal expenses. Notices of complaint were issued by the Office of the BC Privacy Commissioner, but again, all three parties objected, insisting the law did not apply to them under the Canadian Constitution. Months turned into years. In 2022, the BC Privacy Commissioner appointed a former BC Privacy Commissioner to examine the constitutional question. He found that provincial law could indeed apply to federal parties. But instead of complying, all three parties went to the BC Supreme Court to try to have the decision overturned. Another delay. By 2023, the case was set to proceed. Just days before the hearing, Ottawa introduced new legislation aimed at overturning the decision. The three political parties filed for an adjournment. Another delay. The BC Supreme Court denied the adjournment and eventually dismissed the political party's appeal in May 2024. Still, the parties refused to concede. They appealed to the BC Court of Appeal. In 2025, the BC Court of Appeal hearing was finally scheduled, and the complainants thought they might get their day in court. But Ottawa moved again, embedding sweeping privacy rewrites into Bill C-4, backdated to May 2000, trying to preempt the courts entirely. This caused another delay. Now the complainants are working to have the appeal heard in March 26, or at least by June 26. By then, these three Canadians will have spent 7 years in pursuit of one answer, and millions of dollars will have been spent on both sides fighting over it. Think about that. Three Canadians who followed every rule, filed every form, waded through every delay, were fought every step of the way, and all of it to avoid one simple question: what data do political parties have on me? Bill C-4 is an affordability bill, but it has another measure clause. that forces a power grab. It exempts political parties from the privacy rules they impose on everyone else, strips provinces of authority, rewrites the law retroactively for 25 years, and shields political parties from scrutiny. All this manipulation of the law with the weight of the House of Commons to avoid a straight answer about what data political parties hold on Canadians. In GDPR, political data is classified as sensitive and afforded stronger privacy protections. It cannot be processed without explicit consent or clear public interest exemption, and the national regulators have binding powers to enforce these rules. By contrast, Canada exempts political parties entirely, offering no independent enforcement, and has now weakened protections further through Bill C4, cementing our inability to withstand a challenge. If a Canadian living in the EU challenges Canada's adequacy for data exchange because of this stark contrast, what would a court decide? All this leads to a simple truth. When parties put their own interests ahead of citizens like they have in Canada, democracy is weakened. But Canadian political parties are addicted to the surveillance capitalism, what the power of surveillance capitalism affords them. So until this is addressed, how can you ever expect politicians to govern the very thing they are still addicted to? Thank you.